Good morning, everyone. I'm Judge Blake Adams. We're here for small claims non-jury trials this morning. We have two cases on the 9 o'clock docket. Those cases are Cars and More Cars Auto v. Marco Bendo, case 20 SC 664, and Kerry Colvin doing business as the Creative Spectrum v. Scott Hoogie and BWG Companies. Case number 20 SC 679. It appears I have both plaintiffs and both defendants present. Let me first go to Ms. Colvin. Good morning.
Yes, this is Carrie. I'm present.
Good morning. And I see Mr. DeHoogie is present. Ms. Colvin, did you have any witnesses in this case that will be testifying today?
I do. I have two witnesses, Chloe McLaughlin and Monty Richards.
All right. Is Monty Richards present?
I see him. I believe he's muted.
Oh, yes. Sorry. Can you hear me now?
I can hear you now. Are you Mr. Richards?
Yes, sir.
Okay. All right. I'm going to put you back on mute. All right. And Mr. DeHoogie, did you have any witnesses that you planned on calling?
Not at this time.
Okay. Thank you. Let me go to the other case. Who do I have for Cars and More Cars Auto Repair?
Hey, good morning, sir. My name is Ricardo. I'm the owner of the shop.
All right. And what's your last name, sir?
Chaparro. C-H, A as an apple, P as an Paul, the A as an apple, double R-O.
Okay. Thank you. And do you plan on calling any witnesses?
No, sir.
Okay. Thank you. And then I believe I have Mr. Bendo present. Good morning. You'll have to unmute your microphone. Good morning, Mr. Bendo.
Yes, I'm Marco Bendo. Good morning.
Good morning. And do you plan on calling any witnesses today?
Good morning. My name is Edira Bendo. I'm his wife.
Good morning. And Mr. Bendo, do you plan on calling your wife as a witness?
I'm going to talk on behalf of him because it doesn't feel good to talk.
So I'll take that as a yes. I'm assuming, Ms. Bendo, you're not an attorney.
Yes.
Okay, because you can't represent him.
But he had the surgery 2 months ago and then he cannot talk too much. That's why I'm representing him.
Okay, well, you can't represent him. That's what I'm saying, because you're not an attorney. So Mr. Bendo can call you to testify if you have knowledge of the events, but you can't represent him. You can't speak on his behalf.
I'm not feel good. This is the reason. I not feel good, and I can't talk too much.
Okay.
Please.
He explained me everything on his case. That's why I'm here.
I'm sorry?
He explained me everything on his case, what's happened. That's why I'm here, sir.
Okay. All right. Well, when we get to you, Mr. Bendo can call you as a witness then.
Thank you so much.
All right. Thank you. Okay. Let me go back to Ms. Colvin.
Yes.
All right. We're going to go ahead and take, do your witnesses need to be anywhere?
Yes, Chloe McLaughlin has to depart at 9:30 sharp for work.
Okay. All right, we'll go ahead and take your case first. So Ms. Colvin, if you'll raise your right hand to be sworn, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you can either testify at this time or you can call one of your witnesses and question them to provide testimony.
I would like to testify myself, if I may, please.
Okay, now it's 9:07 and you've got a witness who's leaving at 9:30, so.
What I could do is, may I give, because the part that she was present for is the first 1/3 of my testimony, may I read that and then I will ask her if she concurs?
Go ahead.
Okay. May 10th, 2019, I was contacted by Monty Richards, project manager for BWG Companies and Scott D. Hoog, to stain 5 raw wood doors to match previously stained doors and do minor repairs to 3 existing doors at the home of Dennis and Tawny Sherman. I explained that I typically require 1/2 down with balance due upon completion. However, since it's a small job, I would accept full payment upon completion. On May 16th, I received confirmation from Monty via text, and on the 17th, I received an email confirmation of my contract. Monty texted, quote, "If there is more than a couple doors that need touch up, you have my approval to do them, and then just charge me for your time," end quote. On site, day 1, Monty asked Chloe McLaughlin and me to walk throughout the 4-story home and repair all doors to ensure, quote, "they look good." I told him that this would at least triple the work and the price would certainly be higher. He asked me to do whatever needed to be done to make sure, quote, "the doors were right," end quote, and added, "I'm good for it." Some doors were in very bad shape. I explained that the doors would not be perfect. However, I was confident that I could improve the doors where the imperfections and repairs would not be the focus. So I would like to ask Chloe McLaughlin, is this the point where I ask my witness a question?
I've got to swear your witness in.
Okay.
Ms. McLaughlin, can you hear me?
Yes.
Will you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And will you state your name for the record?
Yes, it's Chloe McLaughlin.
Thank you. All right, Ms. Colvin, you may question Ms. McLaughlin.
Okay. Hi, Chloe. Do you remember on the day that we began the job at the Sherman residence, do you remember Monty saying, please walk throughout the 4-story home and make sure all of the doors look good?
I do remember that.
Okay. And do you remember us having a discussion with him how it would at least triple the work and increase the price?
Yes, and turn our 1-day job into a several-day job.
Yes. And do you recall him saying, do whatever you have to do, the doors look good, and just bill me for your time?
Yes.
Do you remember any dispute between us whatsoever?
No, it was very cordial, and it seemed like we had a direct job, and we performed the job and did as we were told.
Thank you.
Any further questions for Ms. McLaughlin, Ms. Colvin?
I don't believe so.
All right, Mr.
Thank
Hoogie, do you have any questions for Ms. McLaughlin? Mr. Hoogie?
I'm sorry. No, I don't.
No questions for Ms. McLaughlin. All right. Ms. Colvin, may this witness be excused?
Yes, unless if she stays present for the next until 9:30, if further questions come up, may we ask her questions at that point?
Well, you've already indicated you have no further questions.
Okay. I'm just thinking, I've never done this before and I may have questions arise, but I understand, I don't know the court procedure. So if I need to ask her all questions, and then I'm not allowed to question her again, then yes, we could excuse.
Correct. Correct.
Okay. Could I have just 10 seconds to gather my thoughts and make sure there's nothing else I want to ask her?
Go ahead.
Okay. Well, I think I'll add, Chloe was present through most of the days on the job. She knows the intimate details of the frustrations over the last couple of years. Chloe, may I ask her if she would like to add anything that I perhaps am not thinking to ask?
Go ahead.
Chloe, is there anything you can think of that you would like to add?
Sure, I would like to add that, so we were not under the impression that if we fixed all doors, well, first we were told to fix all the doors before we were told how many there had been damaged. And so before we started any work, we wanted to ensure that BWG knew the extra labor that was going to go into it. So I went through and I documented every single damage that we could find. And we sent all of that to Monty prior to beginning. So although he said that he was good for it, and they were under the impression they knew what they were getting themselves into because we documented everything and let them know the kind of damage and the amount of damage that there was prior to starting this additional job. So it wasn't the case where they unknowingly signed up for extra labor because we documented the labor. We documented the labor that would be required before beginning that second part of the job.
Thank you.
All right.
Any further questions?
All right, Mr. DeHoogie, any questions for Ms. McLaughlin in light of her last statement?
No, sir.
All right. All right. May Ms. McLaughlin be excused?
Yes, thank you.
All right. Thank you, Ms. McLaughlin. You're excused.
Thank you, Judge Adams.
All right.
Bye-bye.
Bye-bye. All right. Ms. Colvin, you may continue with your testimony, or you may call your next witness.
Okay, thank you. I'll continue. On May 24th, 2019, I submitted an invoice to Monty. June 9th, 2019, I followed up with Monty regarding payment. He sent me the accountant's, Kathy McDonald's, email and explained that bills are submitted to clients on the 25th of each month and paid by the 15th. These are 2 deviations from our agreement. Over a period of 7 months, I sent emails to the accountant requesting payment, explaining that this was not in line with our agreement and causing hardship to my small company. When my emails were not ignored, I received messages that the client was not paying BWG. January 18th, 2020, Kathy emailed, and the accountant emailed, "Unfortunately, the client is not communicating with us," and went on to explain how the client was not communicating with BWG. And then she suggested that I contact the homeowner directly and provided the Sherman's address. On January 24th, 2020, I visited the residence of Tawny Sherman and we talked through the intercom. She explained that BWG broke a sanitation line costing them $80,000, which necessitated a legal dispute. Not to worry, I would get paid. Please allow 4 more weeks and revisit her if I did not receive payment from BWG. I left her a letter of explanation and an invoice, and then I forwarded a copy of everything to BWG. February 20th, 2020, I revisited the Shermans. Tawny answered through the intercom system. After my introduction, the Sherman's attorney through the intercom asked me not to contact the homeowner again. He explained that my contract is with BWG and I should pursue payment from BWG or have my attorney contact him. I said that I understood and left. I have been patient with BWG to the point that the time allowed for a lien to be filed is now expired. The sanitation error has nothing to do with the work I performed. My contract is with BWG, not the homeowner. I feel Scott DeHooge has taken advantage of my position as a much smaller company. He has told me more than once that I am not, quote, that I am not the only one, end quote. And he has been dishonest about his intentions to pay me. In 20 years of business, I have never not been paid, and pursuing payment from BWG has taken hours from which I could be working. I'm pleading with the court to find favor in awarding me not only the invoiced amount, but reimburse all costs incurred pursuing payment and apply interest. and thankful for your honor's consideration and hopeful this may be a step toward holding accountable a company that's not paying their subcontractors.
All right. Ms. Colvin, are you finished with your testimony?
I am.
All right, Mr. Hoogie, do you have any questions for Ms. Colvin?
No, sir.
All right. And Ms. Colvin, did you want to call your other witness?
I would, please.
All right, and that is?
Monty Richards.
All right.
Montgomery Richards.
All right, Mr. Richards, are you there?
Yes, I am.
Will you raise your right hand to be sworn?
Yes, sir.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Will you state your name for the record?
Montgomery Richards.
Thank you, Mr. Richards. All right, Ms. Colvin, you may begin your questions.
Okay. Hello, Monty. May I ask a blanket question? Is there anything in here that you agree or disagree with? Or do you agree with everything that I stated? Or is there anything that you disagree with?
All ever saying that it would be triple the price before you walked through and checked the job. That's the only thing with that verbiage I don't remember.
Well, I said triple the work.
You asked me if I would answer if I recalled those things. I just said that was the one thing I wasn't sure of.
Yes, thank you. I just wanted to correct you. My explanation was triple the work.
Okay. Yeah, because your statement had said triple the price. And you had not said it would cost triple the price, but that's fine. Everything else, yes, was fine.
Okay, well, to clarify for the record, my words were it would triple the work.
Okay.
Which would probably indicate at least triple the price, but because there's further materials needed as well for the additional work, but we discussed it being triple the work.
Any more questions for Mr. Richards?
I wanted him to testify on my behalf that he did hire me for the work.
Well, then you'll have to ask him questions, specific questions.
I don't believe so. Thank you.
Mr. Hoogie, do you have any questions for Mr. Richards?
Just one, Monty. What company did we hire them through?
Which company? BWG companies?
BWG Construction or BWG?
Be BWG Construction, I believe.
Okay, that's all.
Any follow-up question, Ms. Colvin?
Yes, I think I see where this is going. He just asked Monty Richards which company I was hired through, and Monty responded,
Okay.
BWG companies.
Ms. Colvin?
Yes.
You have a question for Mr. Richards.
Yes, Monty, whenever you submitted, whenever you requested that I work for BWG and you sent me an email stating this is where you would like me to submit my invoice, can you tell me which email that was, indicating which company you represent?
That's been a while. I don't recall what that email was.
If it's helpful, I have a copy of it. I've already submitted it to the court.
Okay.
Your Honor, will you guide me in how I may make it easier for Monty to clarify which company he emailed me from?
Well, at this time, you haven't requested that any of your exhibits be admitted into evidence.
Oh, okay.
So,
Thank you.
I have this binder that you
Yes.
sent
Yes.
here that you would like admitted into evidence.
Yes. It would be it's in the tab correspondence. And it would be, let's see here. I have have text messages from BWG or from Monty. Instructing me where to send my invoice.
Well, let me make this easier. Did you send copies of all of this to Mr. Hoogie?
Yes.
Mr. Hoogie, do you have any legal objection to any of the correspondences being admitted into evidence?
I don't have a copy of them, although she may have sent them. I don't have a copy present, so I don't know what I'm agreeing to, but I don't have a problem with emails.
All right, I'm going to admit all of the correspondence in the binder into evidence without objection. Madam Clerk, I will mark each page as composite exhibit A through whatever it goes to. All right, now, so I believe Ms. Colvin, you are referencing composite exhibit 1H, which is an email. No, that's probably not what you're referencing. 1J, which is an email from Monty Richards to Carrie Palermo.
Yes.
And Mr. Richards, to refresh your recollection, that email address that you sent the email from was monty@bwgcompanies.com. Does that refresh your recollection?
Yes, sir.
All right, you may proceed with your questions, Ms. Colvin.
Thank you. And Monty, after you told me to bill you at montybwgcompanies.com, I followed up with you on June 9th to ask about payment because I was not paid upon completion. And you asked me to submit the invoice to a new email. That would be in the exhibit folder as well, Your Honor. And I was told to send the email or the invoice to accounting@bwgcompanies.com. Do you recall that?
Don't recall the exact date, but yes, I would have directed you to do that.
Is there at any point in my correspondence with you any indication that I was doing business with any company other than BWG Companies?
No.
Thank you.
Any follow-up questions, Mr. Hoogie?
No, sir.
All right, I have a couple questions, Mr. Richards. Mr. Richards,
Yep.
Who do you work for?
Pardon, I'm sorry.
Who do you work for?
I work for Diamond Custom Homes.
All right, did you previously work for BWG Companies?
Yes, sir.
All right. And what was your position there?
I was a superintendent.
And what does that entail?
Basically, you're running the project and overseeing the project.
Does that include hiring subcontractors?
That includes, yes, directing subcontractors and scheduling subcontractors.
And as part of your job on the project in question, did you hire Ms. Colvin or the Creative Spectrum to complete and repair the doors?
Yes.
Okay. All right, Ms. Colvin, any follow-up questions for Mr. Richards in light of the court's questions?
May I have 10 seconds once again to collect my thoughts and review? I don't believe so. Thank you.
All right, Mr. DeHoogie, any follow-up questions in light of the court's questions?
No, sir.
All right, may this witness be excused?
Yes, thank you.
Mr. DeHoogie, you agree?
Yes, sir.
All right, thank you, Mr. Richards, you're excused.
Thank you, sir. Have
All
a
right,
good day.
have a good day. All right, Ms. Colvin, any additional testimony or evidence you would like admitted? Remember, you've only admitted the section that you've sent as correspondence. Anything else in the binder you'd like to have admitted into evidence?
May I ask that the entire binder be admitted into evidence?
Well, I have an objection to that.
All right.
I'm going to object as to the relevance of all of the photographs being admitted. I don't think this is a case of the work that was performed. I may be wrong. Mr. DeHoogie, is your defense that payment is not being made because of the work performed?
No, sir.
All right, so I don't find that the photographs are relevant. You have, looks like a personal statement as the first page, and then you have the next section, which is statements and invoices. I would find those are relevant. Any objection to the statements and invoices being admitted, Mr. DeHoogie?
No, sir.
All right, Madam Clerk, I'll admit the statements and invoices section. We'll call these composite 2A through whatever it goes through. Any objection to the personal statement being admitted?
No, sir.
All right, I'll call that Plaintiff's Exhibit 3. And then other than the photographs and the sections we've already admitted, anything else in this, Ms. Colvin?
May I verify with you or confirm with you that the correspondence section has been admitted?
Yes, that was admitted as Exhibit 1A through whatever it goes through.
Okay, thank you.
All right, any other evidence you'd like admitted?
The current, and I brought this in to the court separate from the binder which you're holding. It was the updated statement updated request for reimbursement, the updated charges. And I brought that to the court and forwarded it to Mr. DeHoogie. I believe that was last Friday.
Well, Ms. Colvin, your statement of claim is for $6,198.72.
Well, after I incurred further charges with having to have witnesses subpoenaed and further pursue payment, that I submitted updated charges.
Okay, is that, you mean costs?
Yes.
And you filed that with the court?
I did.
What date?
I believe that was last Friday. I'm looking here.
Judge, I have an Exhibit 1 here. It looks like the evidence clerk was trying to contact your JA to see if you had this exhibit already, but it doesn't look like it's been sent to your office.
Email that to me.
Email it to me.
Yeah. And email that directly to me. While we're waiting on that, anything else, Ms. Colvin?
Yes, I would like to add that, oh, here it is. So my summary of charges and expenses, I did modify that, and I believe that's what you're being forwarded now, and I emailed Mr. DeHoogie and Kathy McDonald a copy of it as well. So originally, for my time that was invested driving up to the homeowner's residence twice to request payment, just representing myself in trying to plead with the court to help me recoup my costs, that took an exorbitant amount of time. And I did consider that when I was asking for payment. And although when I work as an artist, I bill $120 an hour, I reconsidered that, and I thought it may not be fair, even though I could have been making that on another job site with the hours I've invested trying to recoup payment. I thought perhaps it would be more fair to bill at half that rate. So I considered the hours, not all of them, but some of them that I invested in trying to get paid, and billed that at $60 per hour. And so I modified my request for payment at a lower rate. But then I also was a little more realistic in the hours that I invested in trying to recoup cost. But still, I mean, I didn't bill for all my hours. I couldn't. I would have exceeded the small claims court allowance for payment. I think maybe that's the only thing that needs explanation on my summary of charges and expenses.
All right, any objection, Mr. DeHoogie, to the summary of charges, expenses being admitted, dated February 12th?
I don't admit to the admission. I certainly dispute the amounts.
Right, but do you have a legal objection to the document being admitted?
No, sir.
All right, it'll be admitted as Exhibit 4. Thank you, Madam Clerk, for forwarding that to me. Okay, any additional testimony, Ms. Colvin?
May I ask, so do I need to explain each exhibit that's been admitted, or is this something you will review on your own and make a determination, or do I need to call attention to each one?
Unless there's something specific that you think I might miss, I will review each exhibit admitted.
Okay. I think that the most relevant parts of my case are before you, so
okay.
I'll leave it in your hands to review and determine.
All right, thank you, Ms. Colvin. Does that conclude your presentation?
Yes, Your Honor.
Okay, Mr. DeHoogie, do you have any additional questions for Ms. Colvin before I give you an opportunity to testify?
No, sir.
All right, Mr. DeHoogie, any testimony you would like to provide the court or any evidence you would like to submit?
I believe we sent you a copy of the contract with the client.
All right.
Let me
go ahead and put you under oath.
Yep.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. Give me one moment. Do you know what date you sent that?
No, sir.
And what is it I'm looking for exactly?
Contract with the client, the Shermans, between BWG Construction and the Shermans.
Do you know if you filed that in the court file or did you just send it to the court?
I'm not sure.
Madam Clerk, do you see anything in the court file?
I don't see any exhibits filed. Let me check notes tab and see if there's anything in there. The note I have is that Your Honor has the exhibits.
Right, those I think were from Ms.
Okay, it doesn't identify whose exhibits, but that's all I have here.
Give me one moment. Mr. Hoogie, we're not showing receipt of anything. Can you resend that if you'd like that admitted?
I can try to find it. Is it something I can email to you right now, or?
Yes.
I apologize for the delay. Who would we send it to? Do you?
Give me one moment. All right, can you see the email address of my judicial assistant?
Yes, I can see it. Bear with me. Okay, we're working on that right now.
All right, very good. All right, while we're waiting on that, would you like to go ahead and provide any testimony to the court?
Yeah, I can, let me, I'm sending this address, I apologize. The reason for that submission is it's the contract between us and Sherman's. My original thought here is my original question is, I'm being named personally, and a company that doesn't conduct any business is being named in this. She sued the wrong people, and we didn't get into that before, but that's, I mean, it's a simple fact, and I don't know how to introduce that. I don't know what that means, but she's suing me, and she's suing a company that doesn't conduct any business.
Okay, would you like to provide some additional information?
I'm sorry?
Would you like to provide some additional testimony?
Yes. What we've tried to do all along is we've tried to support her efforts in getting paid by this client. We continue to chase payments to other subcontractors, not just Creative Spectrum, from the client. The client has represented not only to her but to other subcontractors that they are willing to pay. When we last got together and we mediated, we felt like our conversation was going to get her 50% of what she had due. She wasn't happy about that, and I don't blame her, but that's what the client represented they were willing to do. They have since gone dark and are unresponsive again on those efforts, but we continue to strive in those efforts. I don't deny that she did the work at that residence. She did not do it for me. She did not do it for BWG companies. We conduct all business as BWG Construction LLC. Under normal circumstances, we have subcontracts that would support all of those efforts, and it would be tied to the owner contract. Why we deviated from that, I do not know. But the simple fact of the matter is I personally did not engage with or hire her. BWG companies did not engage or hire Creative Spectrum. In addition, she's chasing a whole bunch of cost and other things that I'm not sure. I'm not an attorney, but it doesn't feel like those are recoverable. I do know how our contracts are written and why we expressly talk about those, the recoverability of those things in other contract form. So I don't think those are recoverable.
Okay. Does that conclude your testimony, Mr. Hoogie?
Until we get that contract to show you, yes.
Okay. Ms. Colvin, do you have any questions for Mr. Hoogie?
Yes, I do.
All right, remember, questions, not statements.
Okay. Mr. Hoogie, did you ever at any point have a conversation with me about the Sherman residence or a contract or work or a request for work that I would provide for your company?
No.
Is Monty Richards authorized to represent you? And
Monty Richards was employed by and paid by BWG Construction LLC, and he performed the duties of a superintendent. He did not sign any subcontracts. I don't deny his correspondence. I don't deny the conversations you had with him, but Monty never signed a subcontract or an owner contract with our company. This went completely outside of policy and procedure.
No further questions.
All right, Mr. Hoogie, I have a few questions. Do you own or are you a managing partner of BWG companies?
Yes, sir. It's a company in name only.
And is Colvin, any additional questions in light of my question?
No, Your Honor.
All right. Okay, Mr. DeHoogie, do you know where we are on the,
It's been sent is what I've been told.
hey, did you get the email yet? Okay, thank you. All right, thank you. All right, she has received it. She's printing it now. All right. Any objection? And Mr. DeHoogie, did you send a copy of that to Ms. Colvin, or Ms. Colvin, do you have?
No, but I will. What's the email address for that?
Carrie@thecreativespectrum.com.
Is that C-A-R-I-E? I apologize.
CARRI at
No E.
creativespectrum.com.
Your Honor, I'm going to step out of view just to make sure this gets sent right away for you.
All right, thank you. Ms. Colvin, would you like for me to keep your photographs for pickup, or?
Yes, Your Honor. Thank you. And may I ask a question?
Yes,
Will I have an opportunity to make another statement?
you will.
Okay, thank you.
All right, I've received a copy of the BWG Construction LLC contract between BWG Construction LLC and Dennis and Tawny Sherman. Ms. Colvin, you probably have not received a copy of that yet, but do you have any legal objection to it being entered as Defense Exhibit 1?
I don't understand its relevance, but no, I do not.
All right, I'm going to overrule the objection. Defense Exhibit 1 will be admitted. All right, Mr. DeHoogie, any information you'd like to provide the court regarding your Exhibit 1?
No, just that that's the contract between the construction company and the owner of in the Shermans where the work was conducted.
All right, well, it's 13 pages long. Anything in here that you want to specifically want me to look at? Or
no, I guess just the title page that shows that that's who was contracted.
Okay.
Your Honor, actually, may I retract? Again, this is all foreign land to me, but may I object and state the relevance? I've never seen the contract. I didn't have anything to do with the contract between BWG Construction or companies, whichever company he's operating under at that point, and the homeowner. That had nothing to do with me.
I understand your objection, Ms. Colvin. I am going to overrule it. I will allow the exhibit to come in as part of Mr. DeHoogie's defense.
All right.
Anything else from you, Mr. DeHoogie?
No, sir.
All right. Any rebuttal, Ms. Colvin?
I would just like to add that, is this at the point where I'm allowed to make a statement?
Yes.
Okay, thank you. I just would like to add that I have no knowledge of Scott DeHoogie's companies, whether he has an umbrella company and sub companies that operate beneath that. And there was no indication in this process that I was dealing with any other company than BWG companies. The emails that I was provided to submit invoices to were all at BWG companies. I was corresponding with his head supervisor on the job, who was operating as BWG companies. He answered at the beginning of his testimony. The company he was representing was BWG companies, not BWG construction. When I dealt with the accountant, I was dealing with Kathy McDonald at BWG companies.
Okay. All right. Anything else, Ms. Colvin?
No, Your Honor, thank you.
All right. Thank you. All right. Thank you, Ms. Colvin. Thank you, Mr. Hoogie. I'm going to reserve ruling on this case, which means you'll receive a written order, a written final judgment on this case once I have had an opportunity to go through the exhibits and make an informed and legal decision in your case. Any questions?
May I ask what the time frame typically is when you take a case under advisement?
It depends. I think I'll be able to have that out by the end of the week.
Thank you.
Okay. Any other questions for you, Mr. Hoogie?
No, sir.
All right. Thank you both. Have a good day.
Thank you, Your Honor.
All right. That brings us to our next case. Cars and More Cars Auto Repair v. Marco Bendo, case number 20 SC664. Let me go to the owner of Cars and More Cars Auto Repair. Give me one moment here. And sir, could you spell your last name again?
Yes, Your Honor. Chaparro. C as in Charlie, H as in Henry, A as in Apple, P as in Paul, A as in Apple, double R-O.
All right. Thank you, Mr. Chaparro. All right. Will you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Chaparro. Did you have any evidence you'd like to admit to today, or would you like to just give testimony?
Your Honor, Mr. Bendo took the parts from the vehicle, so I don't have any evidence to show you that the car was fixed on my shop. I have a video, but that's not the point at this time of the case, that the car was on the shop or not. So
what about invoices, contracts?
Yes, I have the invoice.
Is that the invoice that you attached to your statement of claim?
Yes, it's the invoice that I attached on the file, correct.
Would you like to admit that into evidence?
Yes, please.
Any objection, Mr. Bendo, to the invoice that was attached to the statement of claim being admitted into evidence?
I don't see any papers.
Well, I have a return of service in the court file, which it would have been included with that. Showing that you were served back on March 4th, 2020. So you would have received that. Do you have any other objection to it not being admitted?
I have received an invoice.
I'm sorry?
Can you talk, because I'm not good for English. Can you talk my wife, please, because I'm not good, really good for English.
You're, Ms. Bendo, you're free to interpret.
Okay, thank you so much.
Thank you so much, I appreciate it.
So we haven't received any invoice or contract, which my husband have done with this gentleman. So we haven't received anything.
All right, I'm going to overrule the objection. I do have the return of service in the court file showing that Mr. Bendo was served, which it would have included the invoice. All right, I'll admit plaintiff's exhibit 1 into evidence. All right, Mr. Chabarro, you may proceed with your testimony.
Yes, sir. The car was taken for Mr. Bendo to my shop on November 2019, after Marco was telling us about the car. He was saying that in another shop, the car was fixed. And after our visual inspection, we determined that the car never been fixed in that way, because there is no way to remove some part of the engine without replacing some gaskets. And the gasket looks like or the vehicle for 20 years. So I explained to Marco what was the plan for us replacing the lifter for the engine, because the car, Marco was concerned about the noise. So the first thing that we did was flushing the engine for clean the oil circulation ducts, and then we tried with a heavy oil. After seeing that nothing happened, we determined that the lifter was bad. The lifter is a part of the engine that open and close the valves. So the only way to replace those lifters is removing the intake. Is when we found the gasket that was pretty old, so there was no way that somebody touched or did something on that car before. After we replaced the lifter, the noise keep on the engine. So the problem wasn't the lifter, the problem wasn't the camshaft that pushed the lifters. It's very hard to diagnose the noise because the noise is coming from the whole engine. So I talked to Marco, what was the problem, and the solution is rebuild the engine. He took like 2 or 3 months to pick up the car. Then he showed up on my shop with other 2 guys. One of the guys has a orange tag for transporters. Those tags normally are for dealers. So I thought, because they talk their own language, I thought they were negotiating the vehicle. When they tried to start the car won't start. And one of the guys that was with Mr. Marco was a mechanic, and he was checking what's wrong with the car. So I provided my tools. I went running like crazy because I thought they were selling the car. I was running like crazy on my shop, bringing some tools, filling the spark plug, bringing some starting fluid. At the end, Marco's friend, the mechanic, said that the problem was the coil, that nothing with the job that we did, nothing. The coil is from the electrical part of the starting, and we work on the physical part of the engine, the mechanical part, not the electrical part. So they went to the auto parts, they bought the coil, they put the new coil. I cleaned the spark plugs for them. We put the new spark plugs and the car runs. In that moment, I thought that they're gonna take the car and Marco was supposed to pay me. Because the first time that somebody took a car from my shop without paying me, Marco used to be a customer from the shop before I bought the shop. And he was like the good customer. He went to my shop to say hi, giving $1 to my daughter, 6 years old, to my son Santiago another $1 for candies, like a good customer. So I never thought that he's going to take the car without paying me, because if I assume that he's not going to pay me, I don't give him the key. And I told to Marco, hey Marco, you can take the car without paying me. And he was yelling me and pushing me. And I say, hey Marco, don't touch me. And I remember that he has in another fight in a body shop. I don't know why, but he was fighting in a body shop because he told me what happened there, and another mechanic that he was in the shop where that happened, he told me about the fight. So when he started to push me, I understood that he wanna do the same thing. So I just backing up and I told him, don't touch me again, don't touch me. And he stayed pushing me, and then he was saying that he's gonna pay me on the next day. And I told him to Marco, don't be like that, bro, don't be like that. Pay me at least the parts. And his mechanic friend told him in his language, hey, yes, the guy replayed the parts because I gave him the old parts. He replayed the parts, pay him at least the parts. and he said that he's gonna pay me when he sold another car. And I said, hey Marco, don't compromise my money in your sales. Pay me this car and done, man. And he took the car and he never paid me. That's why I went to the car. I waited 2 weeks to find out he's going to go back to the shop to pay me. He never paid me, and that's why I went to the court to open the small claim case.
All right. Thank you, Mr. Chabarro. Mr. Bendo, do you have any questions for Mr. Chabarro?
Yes, my question is that Mr. Chabarro,
Ms. Bendo.
I'm sorry.
Yes, it doesn't fix the car. The all is not true. Never push people.
Wait, is there a question? Is there a question for Mr. Chabarro? You'll have an opportunity to testify, but if you don't have any specific questions for Mr. Chabarro.
Did you fix the noise in my car? Just is the car. I'm going over there for the noise.
To fix the noise, you need to rebuild the engine.
No, you say me, I fix the noise. Just bring the car over there. Just for the noise. No, for the coins, I don't know. Just for the noise. You say yes. Okay?
No, because the engine need to be rebuilt.
No rebuild. You don't say me rebuild the engine. You say me, I fix the noise. I bring the car for the noise.
Hold on, Mr. Bendo.
Yes, sir.
His answer was no. Do you have another question for Mr. Chabarro?
What question? Never I push the people.
Okay, I'm not concerned about that. Do you have any questions for Mr. Chabarro?
This is question. To fix the car.
What was the question?
It doesn't not fix the car. You need to fix the car.
Okay, that doesn't sound like a question. All right, Mr. Chabarro, I have a couple of questions. Mr. Chabarro, why did Mr. Bendo bring you the car?
Why? Because the car has a noise.
Okay.
Noise.
And the work that you did that is shown on the invoice, which is Plaintiff's Exhibit 1, why did you make those repairs?
Because when you have a noise in a vehicle, you fix the first thing that could make the noise. You don't replace an engine because the car has a noise. Could be a leaf, a valve, and for that reason you don't replace the whole engine. You start to replace what could make the noise. The first thing normally on those engines that makes noise are the lifters. The lifters are pushing by the camshaft. So you don't replace a whole engine, and you don't pull an engine out of the car because you have a lifter noise. The cheapest way to start is the lifters. Then you see that the lifter the noise is not gone. So you keep digging and trying to find what was the lifter. What was the noise?
Okay. Did Mr. Bendo have any conversation with you about what work should or should not be done?
Yes, he states that in another shop, somebody replaced the lifters.
Yeah.
So when we made the inspection and we saw the gasket that goes on the intake, the gasket looks like 20 years old gasket. So there is no way that somebody moved the intake out of the car without breaking the gasket. So when I saw the lifters, the old ones, the lifter looks pretty warm. So nobody had replaced the lifter in years. And Marco told me that the other mechanic, they charge him like $200 for replace the lifters. And I said, no, that's not possible because just the labor is more, the parts are more expensive. How are you gonna replace a lifter for $200? So after the visual inspection, we determined that the lifter never been replaced before. And the first step, trying to get rid of the noise, is replacing the lifters. When you have a truck and you hear the clicking noise coming from the engine, you check if the engine, the noise is coming from the bottom, the connecting rods. The engine is, the connected rod was good. So we check with a device for noises. We check where is the noise coming from. And then the noise was coming from the middle section of the intake where the lifter goes. So after replacing the lifters with a new ones, because the lifter has a small hole in the middle where the oil is going in to push the lifter, because the lifter works by hydraulic pressure. After replacing the lifters and put the new ones, if the noise is still in the engine, the problem is the camshaft, because the camshaft has a play on the bushing where the engine goes, where the camshaft goes in the middle of the engine.
Okay. All right. Mr. Chabarro, any further testimony or evidence you would like to provide?
No, Your Honor.
Okay. Give me 1 second, and then I'm going to come to Mr. Bendo. Okay. I've got another case that was scheduled at 10. I'm going to admit them into the room and let them know that we're running a little behind. So give me 1 moment.
Mm-hmm.
All right. Good morning, everyone. For those of you who just joined us, I'm assuming you're all here for Christopher Lewis and Jessica Lewis v. ESK LLC, Ralph Epifanio and Michelle Bauer, case number 20 SC 2869. We're running a little behind from the 9 o'clock docket. So if I'm going to put you all in a breakout room, and then I'll bring you back into the main courtroom when we're ready for you. And I apologize for the delay this morning. So give me 1 moment.
Thank you, Your Honor.
And while you're in the breakout room, that'll be your opportunity to try to settle the case before we have the trial. If you want to try to make one last attempt to try to come to an agreement, feel free to do so. Or if you don't think you can, just keep your microphones on mute. All right. Thank you, everyone. We'll see you all in a little bit. Okay. All right. Let me go back to, we're going to go back to Cars and More Cars. Auto Repair v. Marco Bendo. Go. Okay. Mr. Bendo, any testimony you would like to provide at this time?
I'm going to the shop just to fix the noise.
Will you raise your right hand to be sworn? And Ms. Bendo, if you plan on testifying, if you could raise your right hand also.
Yes. I do.
Ms. Bendo, are you going to testify also?
Yes.
Yes.
All right. Do you both swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
All right. Go ahead, Mr. Bendo.
So may I talk, please?
Mr. Bendo, are you calling Ms. Bendo as a witness?
Yes.
Go ahead, Ms. Bendo.
Yes.
Thank you.
So my husband, he took the car to his shop, the gentleman's shop, to fix the car only for the noise. His problem for the car was only the noise. When he took the car to the shop, the guy said, okay, we'll fix the noise. The problem was after 2 weeks when my husband went there, and he did not went just to pick up the car. He was passing by with 2 friends, and then he checked on a car, and
Ms. Bendo, I'm gonna object to your testimony. Were you present for any of this?
I was not present, to be honest, but he tells me everything.
Okay, I'm gonna object to your testimony being hearsay. because you were not present for the events. Any testimony that you can provide that you have firsthand knowledge of?
I haven't been with him when he was to the shop, but I'm telling you, when he came back with the car is not fixed. He's still noise in the car. And then for the guy that said that my husband pushed him.
Okay, that's irrelevant. Okay, Mr. Bendo, any testimony you'd like to provide?
Yes, just I'm going the car just for the noise, and the car is starting good, is running good. Now the car doesn't start. Just I'm going over there. He say, you fix the car? He say me, yeah. The engine need more money. I say, for what? It's not true. Say, I don't know what's wrong. I say, the engine have noise again, please. He say me, no, I don't know what happened. I'm going out of parts, my friends. I buy the parts, and I stay almost 2 hours over there going, my friend, he knows for the cars, he going fix these parts. And
show the part. It's a coil.
Mr. Chabarro,
Yeah.
please don't interrupt Mr. Bendo.
The coil.
Yeah, sure,
the car now is behind my yard. It doesn't start for a long time. I don't know what happened. The engine is not good, and I have the papers too. And the reason is never I'm screen my life. Never I push people my life. I'm 52 years old. Never. I have good family. Never. I'm going to other shop. I pay all everything, but never I'm going to court. It's first time for me. Now I have stress. I don't know. I'm not feel good. I really believe me. I'm not. One person is do the job. I not pay. I pay because I pay more. You don't do the job. You can bring 2 mechanics here. No one. 2. He see the car. Car is not good. It's not running. It's behind my yard. For what I'm screening the people? You do the job and screen? No. Never I push. Never I screen the people. And he give me hard job. He takes me. Look. He takes me. No. Oh my gosh. He takes me. Bad words here. I'm so sorry. I'm so sorry. He say me idiot. He say me motherfucker. It's all here. I say for what? I saw you owner say, oh, they changed the. What's the name? Change the. Fiat. Industry Fiat.
He changed the words when Marco text him back. I'm gonna show this on a court, and then he changed the words. So he was doing very pressure to Marco, texting message to him in the bad words, which.
Ms. Bendo.
Yeah, I'm so sorry. I'm so sorry.
That's all right. Mr. Bendo, I have a few questions. Mr. Chabarro, do you have any questions for Mr. Bendo?
Yes. The car leave my shop running?
Yes, because his friend fixed the car.
That
question was for Mr. Bendo.
Yeah, my friend is fix the car because I'm going to start the car. The car it doesn't start, and my friend is fix the car. I say you fix the car. What happened to the car? It doesn't start. You say I don't know. Yesterday it started. Today is not starting.
Okay, you took the car to the shop because the car won't start.
Yeah, it doesn't start the car.
No, I'm asking you.
Did
you take the car to the shop because the car has an electrical problem?
I don't know.
He brought the car.
I'm asking you if you take the car to my shop because the car won't start.
No, because of the noise.
Ms. Bendo, the question is not for you.
I'm so sorry.
Mr. Bendo, did you take the car to the shop because it wouldn't start? That was the question.
Just I bring the car. I told him I bring for noise. That's it. For the noise.
Okay. Any additional questions, Mr. Chabarro?
The car is on his backyard and he's saying the car is not starting. It's not starting because
Okay, that's not a question.
Okay.
Do you have a question for Mr. Bendo?
No, not yet.
Okay, Mr. Bendo, I have a couple questions. Did you take the car to Cars and More Cars Auto Repair because there was a noise?
Yes.
And what was your conversation with the auto repair shop regarding work to be done on it?
Only the noise.
Oh, the noise for the car. It's it.
So did you authorize them to make repairs?
No.
So then why'd you take it to the auto repair company?
Because he said that it's
because he say me gonna fix the noise. It's it. And he say me, yeah, I do the engine. Don't worry. I say, please. Don't change after say, hey, you need this, say no. Okay. I say, how much? You say, don't do the papers. You say 500. Okay, do it. He never do it. He never fix the car. This is the reason. Never my life. I'm going out of the shop. I pay. I have good records. Yeah, this is the reason. Never I push people. Never I scream people. I have good records. All my neighbors he love me. I have beautiful family. I don't know what happened with him. I don't know. I don't understand. I'm not. He's fix the car. Yes, I pay. I pay more. No, it doesn't fix the car. This is a problem.
All right. Anything further from you, Mr. Chabaro?
Your Honor, I have the first quote that I give it to Mr. Bendo. When I give him the quote, he stated that he's not gonna sign anything because he didn't want records. So on the quote, the old paper, the first paper, he write down the exactly year of the vehicle and the exactly model. And on the quote, it described remove and replace valve lifters and the lifter price. So he knew what was involved on the process to take rid of the noise.
This is not true. Not true. Maybe you do later the papers. I don't know. You put. I don't sign nothing. Just I bring the car for noise. It's not true.
All right. I'm going to reserve anything further from either of you.
No.
May I talk, Your Honor?
No, I don't find your testimony relevant because you weren't present. Your relevant testimony was that the car still makes a noise, and I don't find any of your other testimony relevant. Mr. Bendo, did you have something else?
Yeah, just I'm going to the car just for fix the noise. It's it. It's all. Yeah.
Fix
Okay.
the car.
Fix the cars. I pay the money. I pay more. No, I fix the car. Is pay more. This is
All right. I'm going to reserve ruling on this case. I'll have a final order, final judgment issued by the end of the week, and you'll both receive copies of that. Any questions?
Never pushed in. Yeah, this is. I feel very bad right now. I don't know. See the videos, see everything.
That doesn't sound like a question. Okay. Any questions regarding the court reserving ruling on the case?
Thank you.
No, sir. No, Your Honor.
Okay. All right. Thank you both.
Thank you
so much.
Thank you.
Thank
Thank
you.
you. Have a good day. Stay safe.
Thank you so much.
Thank you.
Judge, I have a question about the exhibit that was admitted.
Yes. I have a copy of it here.
Oh, you have a copy of it?
Yes.
Okay. All right.
I'll send it over.
Okay, thank you.
Okay. Thank you. All right. Thank you both.
Thank you so much.
Thank you.
All right. Sherelle, are you there still?
Yes, Judge, I'm here.
All right. We're going to take a brief recess, and then I'll come back and we'll take care of the next case.
Okay, thank you.
Thank you. All right, Sherelle, are you there still? Sherelle, are you back with us?
I'm back, Judge.
Okay, very good. I'm gonna bring him out of the breakout room.
Okay, thank you for the break.
Okay. All right, good morning again, everyone. Sorry to keep you all waiting. All right, we're here on Christopher Michael Lewis and Jessica L. Lewis v. ESK LLC, Ralph Epifanio and Michelle Bauer, case number 20 SC 2869. Mr. Lewis, let me go to you since your microphone is unmuted and you're one of the plaintiffs. Did you all have an opportunity to try to reach a settlement agreement?
We did, Your Honor.
And did you reach one?
We did not. We tried. Part of the offer had been accepted.
Don't tell me about.
Okay, my bad.
Don't tell me about the discussion.
Understood.
Okay. Do you think an agreement can be reached?
When I explained my side of the story, I was told, let's wait for the judge.
Okay.
So I'm hopeful that an agreement could be reached. I've been hopeful the entire time.
Okay.
But at this point, it is not up to me.
Okay. Let me go to, I don't know who would like to speak on behalf of the defense.
I will.
Okay. Thank you. And it's Epifanio?
Epifanio.
Epifanio. Thank you.
Sure.
Go ahead.
No, I'm not going to make an agreement because I feel that actually the security deposit that we did decide to keep was less than the damage that there was there, but we decided to just get with that and walk away from that. and that was it. I mean, there was more damage than we, quoted for.
Okay. Now, is the defense prepared for trial today? Because I don't see any exhibits that have been.
Okay, Judge, last time we met,
Yes.
the exhibits weren't there, and you asked me to drop them off at your office, and I did.
Okay.
that day. So
Okay.
they should be there at your office. They were in a binder.
Okay.
And the last exhibit that I had was submitted yesterday. Yeah, that's it.
Okay. And did you send a copy of this to the plaintiffs?
Yes.
Okay. And all right, so the defense is ready to proceed?
Yes.
All right, thank you. Let me go back to you, Mr. Lewis.
Yes, Your Honor.
All right. Did you have any exhibits that you sent to the court?
I did prior to our January 13th hearing. I sent the original notice that the defendant sent us, and then I sent the subsequent notice that the defendant sent us. And today, as part of our argument, we would like to talk about some of the picture evidence and how we did not create this damage, and how it's clear to see from the pictures that they created the damage while they were working on the house and then charged us for it.
Okay. Did you send yours via fax?
Via fax, and emailed it to the defendant and the court assistant, or your assistant, Julian, I believe his name is.
Okay. And was that approximately 6 pages?
I believe it was approximately 4. I can pull up the email now and count for you if you'd like.
Tell me the date that you sent the email.
Yes, sir. It was January 5th, and the heading is Physical Evidence Regarding Case Number 20SC2869. And the title of the document is Dear Honorable Judge Adams, and it's 1, 2, 3, 4, 5 pages.
All right. And, what email address did you send that from?
I sent it from help@increasemyt. If you would like, I could bump that up now.
I'm sorry.
help@increase and then MYT. So it's increasemyt.com.
Give me one moment.
Yes, sir.
You said January 7th, correct?
January 5th, Your Honor.
January 5th, thank you. All right, it appears I have all of the evidence that both sides plan to try to admit into evidence. Mr. Lewis, are you and Ms. Lewis ready to proceed for trial today?
Yes, sir, we are.
All right. All right, Mr. Lewis and Ms. Lewis. Ms. Lewis, can you unmute your microphone? All right, will you both raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
I do.
All right, very good. All right, I'll let whichever of you would like to testify go first.
Yes, sir. If I may, I would like to point your attention to the picture evidence of the fixture in the master closet and the granite countertop stain that we are purportedly responsible for.
Where do I find that?
This is in the evidence that the defendant has submitted to the court.
I tell you what.
I pointed out those two pieces of evidence in an email about 6 days ago and shot them over so you could see just those two.
Here's the thing. Right now, nothing that the defendants have provided to the court has been admitted into evidence yet. So if you could just give your testimony, then
Understood.
Once the defense have gotten exhibits in, you'll have an opportunity to do a rebuttal against that evidence.
Yes, Your Honor. So basically, we received the original notice, and the largest claim item on the defendant's list was not in the original notice. It did not come over until the second notice, which is the granite countertop stain. And on December 2nd, the defendant sent me a text message stating that he needed my new address in order to send us our deposit. So we provided that, but instead of sending us our deposit, the defendant wrote a defamatory letter to our new HOA and landlord, which has...
I'm going to stop this. Okay, I'm going to ask questions. I think it might be easier. Mr. Will you state your name for the record?
Christopher Lewis.
Mr. Lewis, what's your relationship with Jessica Lewis?
She's my wife.
All right, what's your relationship with ESK LLC?
He is the former landlord of ours for 6 years.
All right, and what's your relationship with Ralph Epifanio?
Ralph Epifanio was the main landlord of ESK LLC for 6 years.
All right, what's your relationship with Michelle Bauer?
Michelle Bauer was also one of the landlords for ESK LLC that we have spoken to during our occupancy of 6 years.
All right, where'd you rent at?
At 254 Fairway Circle in Naples, Florida, zip code 34110.
Did you have a lease agreement with ESK LLC?
For the first 3 or 4 years, we did have a lease agreement, but subsequent to that, we were paying month to month. We did not have a lease agreement.
Have you provided the court with a copy of the lease agreement?
No, Your Honor, I have not.
All right. Did you have a lease agreement with Ralph Epifanio?
No, Your Honor. The lease agreement was with ESK LLC.
Did you have a lease agreement with Michelle Bauer?
No, Your Honor. That was with ESK LLC.
When did you first start renting at 254 Fairway Circle?
It was 2014 in the summer, and the date was Sunday, June 15th, 2014.
When did you give notice that you were vacating the property?
On October 28th.
And you were on a month-to-month lease at that time?
Yes, there was nothing in writing. We were just paying month to month. Our lease had expired, and we did not continue.
All right. And what date did you inform ESK that you would be exiting the property?
We had told them that tentatively we were moving into our new place on November 15th, and then it would take us a couple days to get out. And then we offered them the property on November 20th, 2019.
And is that the date that you exited the property?
Yes.
What happened after you exited the property?
After we exited the property, we had the neighbor put the key in the lockbox for the landlord. And then we received a text message on December 2nd requesting our new address so that the landlord could send us our deposit. But instead of sending the deposit, he sent a defamatory letter to our new landlord and HOA. And then subsequent to that, he took the handle off of the door and drove it over to our gate attendant and left it in pieces in the box.
Okay, that's irrelevant to why we're here. Why are we here, Mr. Lewis?
Because they're making claims that we damaged the house, but we did not.
So you didn't get your security deposit back?
Correct, Your Honor.
How much was the security deposit?
The security deposit was for $2,300.
Did you receive a notice?
I did receive a notice that I submitted to the court.
All right, which page is that?
That's the first page. That was the original notice that we received.
First page. Help me out here. How does it start?
It is. Oh no, not first page. Third page. It says, "Dear Mr. and Mr. Lewis."
Does it have a date?
December 3rd, 2019.
All
to
right.
Christopher M. Lewis and Jessica L. Lewis.
Okay. And that's 2 pages?
Yes, Your Honor.
Right. Do you wish to admit that into evidence?
Yes, Your Honor.
Do the defendants have any objection to the letter dated December 30th to Christopher Lewis and Jessica Lewis from the landlord regarding the deposit being admitted into evidence?
He said that was December 3rd, not December 30th.
December 3rd, correct.
No, I have no problem.
All right, no objection. Plaintiff's Exhibit 1, which is 2 pages, will be admitted.
Judge, are you looking at a docket line number?
No, I have them printed out.
Oh, okay, thank you.
So I'll send them over to you.
Okay, thank you.
All right, thank you. All right. And Mr. Lewis, did you respond to this letter?
I did within the 15-day time period, Your Honor. That is what I have submitted for my original complaint.
All right, and where do I find that?
That is the original complaint that I filed with the court to take this action.
All right, and where do I find that?
You know, Your Honor, I went down to the court and submitted that, and
Okay, let me rephrase my question. Your statement of claim includes 14 pages. What page number do I find that at? Or tell me how it starts. How can I find it? 14 pages.
yes, it's titled Dispute of Fraudulent Claim on Tenant Security Deposit.
All right. And how many pages is that?
It is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 page, 10 or 11 pages.
All right, give me a moment.
Sorry.
What's the last page of that document look like?
The last page of the document will cover a heading of Section 2 expenses and a summary. And the summary is basically state.
The signature page might be the last page.
Yes.
Okay. Any objection from the defense to admitting the plaintiff's dispute of fraudulent claim on tenant security deposit into evidence?
No.
All right, plaintiff's exhibit 2, which is the dispute of fraudulent claim, shall be admitted. That is, Sherelle, that's 13 pages long.
Sorry, I'm looking at a different version of it, Your Honor.
Okay, all right. And what date did you send this?
That was the date I filed the original claim.
What date did you send this to the defendant?
Date of delivery was 12/21/19. And the date sent is not telling me on my receipt here.
Okay.
This is what I'm looking at right now.
Okay. Or that was the date you sent it, was 12/21.
No, I would have sent it prior to that, so it would have been
date of receipt.
The date of receipt is 12/21/19, Your Honor.
All right, thank you. All right. Any additional testimony you'd like to provide, Mr. Lewis?
There is one other piece of evidence that we had submitted.
Okay.
That is December 27th, which is the response to that complaint.
Okay.
And it's titled Dear Mr. and Mrs. Lewis. And it's one page and it's signed by December 27th. Yes, sir.
Right. Does the defense have any objection to admitting plaintiff's exhibit 3 into evidence, which is a letter from Ralph Epifanio, ESK LLC, to the Lewises on December 27th? Any objection?
No.
All right, plaintiff's exhibit 3 will be admitted. All right, any additional evidence you want to admit, Mr. Lewis?
No, Your Honor.
All right, any additional testimony you'd like to provide?
Not at the moment, Your Honor.
All right, does the defense have any questions for Mr. Lewis?
Not any questions, no.
Okay, all right. Ms. Lewis, would you like to testify?
Not necessarily if I don't need to, but if you would like to hear me talk, I will.
To you, this is your case.
Well, I don't really feel like I need to add anything that my husband already said. I mean, he pretty much explained everything.
Okay, all right. All right, then does the plaintiff rest at this time?
Yes, Your Honor.
Okay, all right. Mr. Epifanio, I'll come to you next since you've got your microphone unmuted. Would you like to provide any testimony or admit any evidence at this time?
Yes.
All right, will you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. All right, Mr. Epifanio, are there any exhibits you'd like to admit into evidence?
Probably that whole book that I gave you, Your Honor.
All right, Mr. Lewis, did you receive a copy of Mr. Epifanio's evidence?
I did, Your Honor.
Any objection to anything in this book being admitted into evidence?
No, Your Honor.
All right. Okay, just a minute. I think for simplicity's sake, Madam Clerk, we're just going to admit the whole binder as Defense Composite Exhibit 1.
Okay, thank you, Judge.
All right, Mr. Epifanio, is there anything you'd like to direct me to in your exhibit?
The first one is the one he submitted. I think his 3 was the letter on December 27th stating all the things that we were holding back money for.
Okay.
That needed to be repaired. And it happened to be more than the $2,300 deposit. But we just stopped it at that because that's all we had. And there seemed to be even more damage. But again, we weren't going to go to court or anything to try to get more damages. We just wanted to let it go with this and walk away.
Okay.
And also as another note, this particular house, before Mr. Lewis and Mrs. Lewis moved in, this house had been totally remodeled. No one else had ever lived in the house. They were the very first renters. So everything in this place was in great shape. We have, proof of the construction company. Joe Epifanio is on here. He's my realtor. He was the one that listed it. He took the photos. He was the original listing. And in the original listing, which is in the documents, shows and states it's totally remodeled. So the house was completely cleaned and totally taken care of before the Lewises moved in because we were showing the property.
Mr. Epifanio, I have a question before I let you move on so I don't forget.
Sure.
In the letter to the Lewises dated December 27th, there are a couple of lines that I have a question on. The third line on the itemized section says AC filter replacement.
Right.
$50 and then in parentheses $340. Can you explain that?
Yeah, I charged him 50. It was worth, with all the stuff that they had to do, it was $340 charge to me.
I don't understand.
The heating and air guy charged me $340, you know, to come in and repair anything and check over the system. But I only charged the Lewises for the filters because as per the contract, the rental contract, the tenant is responsible for replacing any light bulbs, replacing any air conditioning filters and anything like that. And in here, towards the beginning, we show a picture of one of the AC filters. They were never replaced, and they were totally dirty. So we just, that was the $50.
Okay. Now, repair blinds in bedroom 3.
Okay.
You've got in/C. What does that mean?
No charge.
Okay.
I didn't charge him for those.
All right. And then in parentheses is what you paid.
Correct.
Okay. Okay. Let me make a note of that.
Okay.
All right. Mr. Epifanio, let me ask you a question that I asked Mr. Lewis.
Mhm.
Is a copy of the contract with the Lewises, the lease agreement, is it in this binder?
Yes, it is.
Okay. Some of your tabs did not stay attached.
Oh, okay.
All right, but you're stating that it is in here.
Yes, sir.
Okay. All right, go ahead with your testimony. I'm sorry to interrupt.
And the other thing I would like to say that at the time that they moved out, my realtor, Joe, because I was not here, I live up north, asked to do a walkthrough, and he totally turned it down. I mean, I think that this whole thing could have been avoided if he would have done a walkthrough and talked about different things, but he didn't. He refused. So anyway, so that's all I have to say other than the evidence that I have. I mean, I could go through, he talked about a stain on the granite countertop in the bathroom. I submitted, as a matter of fact, I submitted it yesterday. It's in there in the thing. It just shows the contractor cost that we had put a brand new countertop and cabinets in the bathroom. So when we went in there, before we had anything repaired or anything, you know, I sent the original letter to him on December 3rd. I think it was, that he admitted to, and I said, okay. Yeah, December 3rd, saying that I was going to keep back the security deposit. And I quoted the Florida statute that is required by law to put into the letter. Now, at that time, of course, I didn't have all the costs. He had just gotten the keys on December 2nd. And I did not have all the costs readily. So I started to put all the costs together and everything. And that's when the December 27th letter went out with what I was going to charge him for and what we were getting charged for to fix some of these things. So he was talking about the, again, the granite countertop that we took pictures of. That was a stain in the granite countertop, which again was brand new when we remodeled. I called in a company, and it's, let's see, let me see where that is submitted. It was called Countertop Solutions, and they came in and I asked them, can they clean up this granite? And they said, absolutely not. The stain had gone through. And they gave me the price of $1,100 to replace it. That's all that could be done. That included the the inlaid sink and everything, because everything was one piece. So that's where the $1,100 comes through. And he said that the people that were painting it or the house did that. No, that stain was there from when they did. If if it had been done by the painter, it would have not soaked in like it did. It was a soak in through the granite, so it had been there for a time. And then as far as the light in the bathroom where it was hanging, that particular light, they must have replaced because it had that part, you can see a rectangle. That was a fluorescent light. Okay, we had to replace it with a fluorescent light. By code, in the bedrooms, you have to have fluorescent lights, not regular light bulb lights. That's a code thing for the rentals. So that had to be replaced. So, that's a code issue. That's all I have right now.
Okay. I have a couple of additional questions before I let Mr. Lewis ask you some questions.
Okay.
The residential lease agreement, appears to be between ESK Family Partnership and Christopher Lewis and Jessica Lewis. However, you're in Plaintiff's Exhibit 3, you've signed it as ESK LLC. Can you explain the difference there?
Yes, it was originally a partnership, and my father passed away, and the partnership was under his name. And so when he passed away, and the way the trusts and all worked, it was passed on to 6 kids. ESK stands for Epifanio 6 Kids, and me and Michelle are the managing partners of it, and that was all the estate attorneys changed it from the Epifanio partnership to or ESK partnership to ESK LLC.
Right. So you're not objecting to the fact that ESK LLC is who now would have the residential lease agreement.
Correct.
Okay.
And the other thing is, we tried a couple times to extend the lease. We sent copies to him for amendments to lease, which I've included in the evidence, and he would never send those back to us signed. So we tried to extend the lease by amendment, and we did it a couple times, and he would just never send it back.
Okay. All right. Mr. Epifanio, does that conclude your testimony at this time?
Yes, sir.
Mr. Lewis, do you have any questions, or Mrs. Lewis, do you have any questions for Mr. Epifanio?
Yes, I do, Your Honor.
Okay, go ahead.
The first question is, I would like to ask, how come the granite countertop stain was not in the original complaint or the original notice that was sent to us, seeing as how it's the largest item deduction? You would think that would not go unnoticed in the original walk-around.
It is in the original complaint on December 27th.
No, but the original notice is December 3rd, where instead of the granite countertop, there was a garage door opener. And in our evidence, you can see that the defendant actually, prior to that, obligated to fix the garage door opener and then tried to charge us for it on December 3rd. And then when we wrote our complaint back to the defendant.
I don't hear a question there.
So the question is, how come it was not in the original complaint?
The original letter of December 3rd is not a complaint. It just, all I have to do as required by the Florida statute is send you a letter that I'm going to hold back money from your security deposit. I don't have to put everything in there that I'm going to hold back for, because at that time, I don't know all the items that I'm going to hold back for, because I have to go through the house, and it was just too quick. So all I'm required by statute is to submit a letter that I'm going to hold back security deposit. That's it. And then that's,
if I can get this,
that's the letter on December 27th that shows what I'm holding it back for.
So if I may, the original walk around, for the record, was done in haste, and we did not notice the largest item deduction.
You did not do a walk around.
No, but you did, and that's why you sent the notice. So I just want, for the record, to be clear that you're stating that you did it quickly and you did not notice the stain on the granite countertop when you sent the original December 3rd notice.
You know what? I did a quick, went in there, saw the damage, and then I sent out the letter. I didn't do a conclusive walk around.
Okay, can I ask you, Ralph, about the picture of the granite countertop stain?
Sure.
Can I point out the cutting board that is there with the brush marks on it that shows someone who's using it as a surface for the stud filler? And it looks to me like somebody was dabbing their paintbrush on that cutting board and then spilt the stain on the granite countertop. So you're stating for the record, that's not what happened, and that's not why you didn't put it in the original notice and you put it in the second notice?
For the record, that did not happen. That was the painter who put that there later.
So are those plaster droppings on the counter in the picture there?
I have no
Was
idea.
someone working on the bathroom before you took that picture?
No.
So there wasn't school lights in that bathroom that had to be updated per code, as you stated?
I think that picture was sent to me by the people that were fixing the house. I also had them send me pictures for their record.
So you're stating for the record, you cannot be sure that they didn't stain the countertop because they're the ones that sent you the picture and you didn't notice on the original walkthrough.
I can state for sure that they did not stain the countertop.
But how can you do that if you didn't see it for yourself?
I did see the countertop because there's 2 other pictures that I took. That the stain was
But
there.
you didn't submit those for evidence and you didn't put that in your original notice. Understood.
Actually, Judge, they are in evidence in my binder.
Understood. No further questions.
And they were given to Mr. Lewis.
Okay. All right, Mr. Epifanio, any additional testimony you'd like to provide in light of Mr. Lewis's questions?
No, sir.
All right, would you like to call any witnesses at this time?
I'd just like to call Joe Epifanio.
All right, good morning, sir. Will you raise your right hand to be sworn? Swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. All right, Mr. Epifanio, you may ask Mr. Joe Epifanio questions at this time.
Joe, just want to present to you what is your, I'm not good at this, asking legal questions, but what is your relation to me as in the sense of this property?
I was the real estate agent. Obviously, we're related family, but also I was the listing agent on this property.
And when you listed it, was the construction completed and ready to show?
Perfect, ready. You followed all the instructions.
Okay, so we had a great property that was completely done, ready to show. And then at the end, when Mr. Lewis moved out, did you ask Mr. Lewis to go for a final walkthrough?
Several times I tried, yes.
And what was his response?
No, and on the last call, he just hung up and used.
I object, Your Honor.
And said.
Was there an objection?
Yes, Your Honor, that's not true. I agreed to do the walkaround.
Hold on. Only legal objections, no factual objections. You'll have an opportunity to do rebuttal. Go ahead.
Understood. I'm sorry.
Overruled. Go ahead, Mr. Epifanio.
Okay, so I did try to reach him several times. Finally, on the last time, he just hung up the phone on me and said, no, we won't be moving out early, click.
That's all the questions I have.
All right, Mr. Lewis, any questions for Mr. Joe Epifanio?
One question, Your Honor. Did I get that correct, Joe, that you said when I hung up on you that I said that I won't be moving out early, not that we wouldn't be moving out on time?
That is correct.
Okay, just making sure. Thank you, Your Honor.
All right. Mr. Ralph Epifanio, any additional questions for Mr. Joe Epifanio?
No, sir.
All right.
Your Honor, Joe has to go to work. Can I excuse him, please?
Yes. Any objection to this witness being excused?
Not by me.
No, Your Honor.
All right. Thank you, Mr. Joe Epifanio. You're excused.
Thank you, Your Honor.
All right. Thank you. Have a good day. All right. Mr. Epifanio, any additional witnesses you'd like to call?
No, sir.
All right. Ms. Bauer, since you're a named defendant, would you like to provide any testimony?
I think she's having computer issues.
I'm sorry. Somebody was talking to me.
I don't know if you can hear me.
I can hear you, Ms.
For some
Bauer.
reason, I can't hear any of you.
You might try.
Can you guys hear me?
Yes.
I don't know what happened. Oh, wait.
Can you?
No. Oh, now I can hear you. Now I can hear you.
All right. Ms. Bauer, can you hear me now?
Yes.
All right.
Hear that last like 3 minutes.
Okay. Well, since you're a named defendant in this case, would you like to provide any testimony today?
No, sir.
Okay. All right. All right. Anything else then from the defense, Mr. Epifanio?
No, sir.
All right. Let me go back to the Lewises. Mr. Lewis or Ms. Lewis, would you like to provide any rebuttal, testimony, or evidence?
Just a short rebuttal, if I may, Your Honor.
All right, go ahead. You're still under
Just
oath.
for the record, I would like to let it be known that we did offer them the house 10 days early and to do a walk around. And they didn't want to do the security deposit refund process at the time. And that's why we waited until December 2nd. And when we came home from our vacation to London, they would not let us back in the house to do a walk around on December 3rd, because that's when we arrived back from London. So there was no way for us to go through the house with them and confirm, contrary to their statements of saying that we could have.
Okay. Any additional testimony you'd like to provide as to any of the evidence admitted for the defense?
Yes, if I could talk more about the picture of the granite countertop stain and relate it to the picture of the master bedroom light, you can actually see the dark substance in the picture of the master closet fixture, and you can see where they use that dark substance to fill the stud holes of the old light fixture. And then if you take a look at the stain on the granite countertop, you can see that was the same substance that they were using in that master bedroom closet. And that's why these plaster droppings are all over the counter there, because they were fixing that light. And whoever was filling the stud holes used that cutting board as a surface to prevent spillage. And that's why there's brush strokes on the cutting board. And they spilled that substance on the countertop. And as the defendant stated, it's not his picture, it was the worker's picture. So there's no way he can be sure that we stained that granite countertop. And the fact that it is not in the original notice speaks volumes.
All right, any additional testimony you'd like to provide for the specific charges that they assessed?
Yes, Your Honor. If I may talk about the AC filter replacement, you can see in our complaint that we complained about the air conditioner since the first year we moved in there. And what it was is the ducting in the home had not been replaced since inception, and everybody in the neighborhood had to do the costly repair. And as soon as we moved out, my wife actually has a relationship with the new tenants. And they told her that all that work was done as soon as we moved out, all the ducting was replaced. And the inside house cleaning, in the original complaint, I have messages going back and forth with the original realtor, Vivian Lugo, to show that we complained about the house not being cleaned. And it was Joe Epifani who told us that they would forego that out of the deposit and not charge us for it when we moved out. And that's why we didn't have the house professionally cleaned. and the repair holes in the walls and all the rooms and broken door jams, the holes in the picture evidence, except for one minor scraping on the wall of plaster, the holes the defendant is referring to are nail holes, which are considered normal wear and tear by all standards that I can find on the internet. And as for the broken door jam, the house suffered a direct impact from Hurricane Irma. And all the doors were doing that, and so were the sliders. And I mentioned in my original complaint how I had to take them out and clean them, and that we were having problems with all the doors because of the extreme humidity in recent years and because of that hurricane. So the door jam simply wore itself out. You know, pretty much everything on the entire list is all due to normal wear and tear, except for the one broken light covering that we admitted to breaking in 2017. Other than that, all of this other stuff is stuff that had to be replaced because we lived in the home for 6 years and it was due to normal wear and tear.
All right, anything else, Mr. Lewis?
No, Your Honor, thank you very much.
All right, thank you. Any final rebuttal from you, Mrs. Lewis?
No, I just want to remind you that we did live there for 6 years, and everything that my husband's explained, I mean, it's normal wear and tear. We have 2 teenage kids. They knew all of that.
All right. Well, I have a lot of physical evidence to review before I make my decision. So I'm going to reserve ruling on this case. I should have a ruling out by the end of this week, and I will have that sent to you. I think we have everyone's email addresses, so we'll send that to you via email as well as hard copies in the mail. Any questions about the court's reservation of ruling in this case?
No, Your Honor, we understand.
All right. Anything from you, Mr. Epifanio?
No, it's okay.
Okay. All right. Thank you, everyone. Thank you for your appearance here today, and stay safe and stay well.
Thank you, Your Honor.
Thank you very much.
Thank you. All right, Sherelle, are you there?
I'm here, Judge.
Okay, so I have everything printed in all 3 cases that we admitted into evidence. So when I'm done, finished with making my rulings, I'll send them over to you.
Okay, thank you. I appreciate that, Judge.
All right. Any questions for me?
No, I thought I was gonna pass out at my desk when that hold binder was admitted. I was like, oh my God. I feel bad you have to read all of that stuff.
So Defense Composite Exhibit 1?
Yes.
I didn't know how else to do it.
I know.
It's just
easier just to.
Yeah, I think so.
Yeah. So thank you.
Okay. Thank you. Have a great day.
You too, Judge.
Are you with me? I don't even know. Are you with me tomorrow?
We have tomorrow.